niche that, oh, it is a special niche that has a lot of nuance. And you guys know that because you've submitted some really excellent questions that we're going to cover today. So it's 10 o'clock and I'm going to go ahead and start because this is recorded, so you can go back and watch it at your leisure. But for those of you joining live today, feel free to put your questions in the Facebook group and we will get to those. I'm going to go through things pretty quick because I do want to make sure I get to everyone's questions. And like I said, we've got some great questions. So let's get started. I will repeat myself just because I know there are some stragglers that come in. I am Shelley Jean John. I'm a family law attorney. I've been practicing for nearly 22 years, exclusively family law. And I am one of the founding faculty members at the Alumni Institute. So this is where we enjoy giving you guys realtors answers to the very specific niche of divorce real estate. So let's get started. The first question comes from Courtney Silverman, and she asks, what language can be in an order to assure compliance to an order, for example, to sell the marital home? Oh my gosh, if every attorney had that magic language, every single transaction would go through very smoothly. Unfortunately, there aren't any magic words that can be put into an order that is going to assure compliance. So understand, an order is just a piece of paper and somebody's either going to comply or they're not going to comply. What you want is teeth, what we call teeth in the order, so that if they don't comply, there are ramifications that they are aware of in advance to hopefully deter them from the bad behavior. So it could be something like, in the event that the party fails to grant the showings, or they interfere with the ability for inspectors to come in, that the other party will be permitted to have access and exclusive use and access to the party's property, or that you can put in financial penalties. Understand, the courts don't like to take really draconian measures at the outset, but sometimes attorneys can get parties to agree to language that maybe the court wouldn't otherwise grant. So it's really up to the attorneys to put as much, as I say, teeth, grit into the order to help to persuade somebody to comply. All right, in a high conflict divorce, what is the protocol in communication? And another part of the question, there's kind of a three-part question. What if the sellers want to limit communication copies to their attorneys to save billable hours? Let's tackle those two first. So in a high conflict divorce, or really in any divorce listing, you should exercise a standard protocol that we use at Alumni Institute for communicating with the other parties. And that is to ensure that they see all of your communication as being neutral, which means that you're not communicating just with one party. You're not sending emails always directed to one particular party. You are not aligning with just one person. So you want to make sure that your communications are alternated. So what we say is, if you talk to the wife this time, maybe you talked with her and met her for the listing agreement, you're going to talk to the husband next time. And it could be about whatever it is. You're going to talk to him next time. We do not recommend that you talk to people together, because that is just a recipe for a blown up disaster. But you do want to alternate your communications. In email communications, what we recommend is that you send the same email to both parties, but that you don't necessarily send the same thread, because you don't want them responding in the same thread to each other. And there you end up again in the midst of World War III, and you don't need to be in the middle of that battle. What if the sellers want to limit the communication copies to their attorneys? You have to, unless you are appointed as an expert in the court order. The parties are your clients, not the attorneys. And so if the parties say, don't send it to my lawyers, then you don't send it to the lawyers. But keep in mind that you also want to maintain a good relationship with those lawyers. So it's a fine line you walk, but really ethically, you are bound to what your clients are telling you to do. unless you get appointed as an expert, in which case you can have the attorneys put in the court order that the realtor shall communicate with the attorneys and the parties. All right, you have another question. Courtney is all full of great questions. The next one is, if you are appointed to sell the marital home in the final judgment, but the listing agreement expires because there's been conflict, which this is not an uncommon situation, does the broker still have the property listing through the court order? So probably. It depends on the wording that is in the order. So if the order says that Courtney Silverman is appointed as the realtor to list and sell the property, the parties shall immediately cooperate and execute the listing agreement. Then a party does have a good cause to say that you are still the listing agent and that the parties need to renew the listing agreement. Also, just keep in mind when you are doing these listing agreements, you want to add on some extra months. You don't want to do a short listing agreement because divorce listings can take a little bit of extra time. So you need to build in that padding into your listing agreement. All right, I hope I answered your questions on that. Let's see, the next question I have here. What if there's a restraining order on the out spouse and they show up at the property? So again, this is one of those nuances of family law, and you want to make sure that you understand restraining orders. So when there is a restraining order, one of the parties is restrained from going to the property generally. Now, there are restraining orders that don't necessarily restrain a party from going to the property, but 98% of them do. So if you will want to ask the parties, is there a restraining order in this case? And you're going to want to look at that restraining order and see if the property is covered. You are not the police and you are not the court. So if the other party arrives at the property and if the restrained party arrives and the protected party is not there, then you would say to the restrained party, I understand that there's a restraining order and you need to not be here at the property. I need to ask you to leave. And then at that point, if they don't leave, you can notify the attorneys and let them know what's going on. But at that point, it's really up to the other party to be notified, and then they need to take action. And that other party probably would want to call the police and have them remove the restrained party from the home. But that restraining order does not protect you. You are not part of that restraining order. It is protecting the other party. So it is their obligation to go ahead and call the police and take care of that. But you do need to let them know what's going on at that time. But, you know, they're both your clients. So you do want to say to the restrained party, hey, you know, you're not supposed to be here. I need to ask you to leave. Is there something you're needing? And they might say, well, I need to know what's in the house. And you say, okay, well, call your lawyer and have them work that out. Maybe they can get video or some other items, photographs of what's in the property. But for right now, I really need you to leave. So do it as friendly as you can, and then notify the other party of what's going on and don't get in the middle of it. All right, next question. What should we do if a court order stipulates a list price that is outdated or inaccurate based on the market value? So this is not uncommon also. Attorneys, we think we're so smart. And we think that, well, let me tell you how it happens. So we're sitting in court. We have one party who has been resisting the sale. And finally, they come to the table and they say, I will sell the house, but not for less than $400,000. That's the only way I'm going to agree to sell the house is if we sell the house for $400,000. And so the attorney who's representing the spouse who's been wanting to sell is like, yay, we finally have an agreement. Let's put that in the order. And so what they'll do is put the $400,000 in the order, just so excited that the house is now finally going to be listed. You need to tell the lawyers that you work with, please don't put the listing price in an order, because I'm the one who is the expert on the listing, not me, the lawyer. You are the one who is the expert at determining what the list price should be, not the lawyers, not the parties. So what they should put is that the property will be listed for sale at a price agreed upon between the parties as recommended by the realtor. Okay. if you can get the lawyers to get into that habit, then you won't be put in this situation. All right, so now let's say you're put in this situation and there's a list price. You need to talk to the parties and recommend to them all the reasons why this is not a good list price, and ask them if they will agree to use a different list price. And if so, then to notify their attorneys. Once you get everybody on the same page, then you should be fine. In our area, and in this, I'm going to say, does not necessarily apply to all areas. So you need to talk to the lawyers. In our area, if the parties agree to a different list price and they sell the listing agreement with the different list price, then that suffices. We don't have to go back and redo the stipulation, because the party who wanted it at 400,000 is now agreeing to sell it at a different price. There's a signed agreement, everybody's on the same page, and everybody can go their merry way. So you may have to, you first have to convince the parties why your price is the better price. Sometimes it's not going to work. Sometimes you're going to have that resistant party who says, nope, it's got to go for 400,000. And if you just cannot get anybody to budge, then you may need to list it at 400,000 and wait a little while to show them that there's nobody who wants to buy the property at 400,000. It's just one of those things you might have to just play it out and see what happens. All right. Let's see, what should we do? Let's see, what are the common circumstances in which a realtor would be called on to testify in court? And before I answer this, I need to just take 1 second. Okay, let's see here. All right, common circumstances in which a realtor would be called on to testify in court. Oftentimes, well, first of all, before you are serving as the sales agent, you might be called on to testify to a value that you've done for a party or for the parties. So you might do a comparative market analysis of some sort, maybe a broker's price opinion, and then one of the parties may be trying to get the court to use that number for some reason, and so you may be called on to testify to that report. Another time would be if you are the sales or listing agent and you can't get one of the parties to sign the listing agreement, or more likely you're in the middle of, you've got a sale, a buyer, and one party won't sign the contract. And so you may have a situation where you have to go in and explain to the court why this is a good offer and why you recommend that the party should accept it. And then in the very worst case scenario, where you have one party who has really sabotaged the sale, you may be called on to testify about your efforts to sell the property. It's really, 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 I cannot stress it enough, important that when you are in that situation, you must always maintain your neutrality. If you start to align with one party and you're writing declarations that are smearing the other one, you are on the phone all the time with that attorney and that party, and the other attorney and the other party are not getting your attention, then you are really going to lose even more the trust of the non-cooperative spouse. So that kind of takes me back to neutrality is the bedrock and the foundation for success in this niche. If you cannot get the parties to trust you as a neutral, then the listing is going to likely fail, or you're going to have a lot of trouble getting it through, because it is your relationship with each party, the trust and authority that you build with them, that enables you to get them to agree with your opinions and your recommendations and your requests. Once you start aligning with one of the other parties, or if one party thinks you're aligning with the other party, you lose that trust. There's a breakdown. And I can tell you, anybody who's been through it, you know that moment when everything kind of fell apart. And so you need to make sure that you can maintain that relationship. I mean, I've got cases right now where the same thing is going on. The parties don't trust the realtors, and the realtors are not acting as though they are representing the interests of both parties. And you have to remember, this is what makes it different from a regular listing. You have two people with opposing goals and interests, with zero trust for one another or the court system or their attorneys probably. And you are trying to represent the interests of both people. You cannot forget that you are responsible for representing both people. Once you forget that, you're going to be in a mess. And that's when parties go back to the court and they ask for a different realtor to be appointed. And it has happened many times before where where realtors put in 6 months, 8 months of time on a listing only to get replaced by a new realtor who is neutral. So be careful. All right, next one. How do you divide? Thank you, Sarah. How do you divide the assets when the parties own several properties? I'm going to answer this one. I'll go back to another one. So assets are divided according to the laws in your state. So in California, we are a community property state. In Michigan, we are an equitable distribution state. So it just depends on how properties are divided in that jurisdiction. But generally what happens is the courts will look and see, does one party have the ability to buy out the other party's interest in the property, whatever that interest ends up being. It's not necessarily 50%. So whatever that interest is, does the party who wants to keep the property have the ability to, number one, pay for and buy the other party's interest? And number two, if the other party is on the loan, does the party who wants to keep the property have the ability to refinance to get the going away party off the loan? If that is true, then what the courts like to do is kind of put the properties on a balance sheet and see, at the end of the day, you keep this property worth 200,000, I'll keep this property worth 300,000. And at the end of the day, there's just $100,000 difference that needs to be dealt with. But again, you want to make sure that you're not on the loan and that you're going to be able to get the interest that the party's entitled to. So when there's several properties, you may find that there are multiple appraisals or CMAs. You may find that you really need to get a lender in or a CDLP in the case early so that the parties who want to keep each of the properties are working that out with the lender early. One of the things that is very frustrating for a lawyer is for us to get down the road where we've negotiated, okay, he's going to keep this property, she's going to keep that property. And now a year into the process, we find that one of the parties doesn't qualify. That's awful. Also too, if we put it in a judgment, one party has 45 days to file the refinance and remove the other party's name from the mortgage, and that 45 days goes by, 60 days goes by, they can't do it, and now we're kind of back at the starting gate. Or sometimes we put in the order that if the party doesn't refinance by the required deadline, then the property goes up for sale immediately, which can feel like a very draconian type of a result for somebody who is planning to keep the property and is not planning to move out. Okay, let's see. How can we get started breaking into this niche? That's a great question. And I'm going to take just a moment because I think a lot of you are in a similar situation where you have other people who are working nearby, since we're all working from home these days, or a lot of us are working from home these days. So I need to yell at my husband real quick. So just give me a half a second. All right. Lashing given. Okay, so how can you break into this niche? At Alumni, we have a couple of different things for you to, this is what we teach, right? We teach people how to break into the niche and how to serve in the niche. So there's a couple of different things we offer. We have boot camp, which is if you are just wanting to really kind of get into it and you want to serve the parties well as a really good divorce real estate realtor, then boot camp is a great way to get started. That's going to teach you the step-by-step process that Laurel has taught for how to do a divorce listing and how to market to your sphere that this is what you do. And that's a great place to start. Start with your sphere so that they understand that you have some additional training and skills in this niche and that this is what you do. You need to get the word out to everybody. And then, of course, we have our CDRE program, and that is where we teach realtors how to become true divorce real estate experts. And in that, that's where we train them on really the deep nuances of it, and then how to market to attorneys and how to, and we don't really like to say market to attorneys, but you're really serving as a resource for attorneys. And so we give them the step-by-step process to do that. We give them all of the tools to do that. And we also teach them how to communicate with lawyers. How do you have those initial conversations with lawyers? So anyway, talk to Steve. He is our director of enrollment about the different programs that we offer. And of course, we have this Facebook group where we post videos and you can learn all about the nuances of divorce real estate. But my short answer is to break into the niche. First, you want to get trained so that you know what you're doing in the niche. And secondly, reach out to your sphere. Let everybody know that this is a special thing that you do. Everybody knows somebody who's getting divorced at any given point in time. So let them know, and then you can break in that way. And of course, you're welcome to talk to Steve and look into our other programs. Okay. Did not mean to make that plug right there, but it was kind of a perfect spot. Oh, and let me tell you, Divorce Boot Camp is on sale right now. I don't know if it's on sale, but I know it's at a low price right now. So take advantage of that. Okay, another question we have is, what appraisal will the court select? His, hers, question mark, and what happens with agent commissions and escrow fees if one party buys the other out? That's a great question. So let me first start with, what appraisal will the court select? That's when you might have to testify. And so you might have what we call the battle of appraisers, where each party's appraiser or each party's agent testifies as to why their number is the more valid number. And it's really about which party, which expert convinces the court that their number is the most valid number. And that's the one that the court will go with in a buyout situation. It's not about his or hers. It's really about who can best support the numbers that they've given. And this is also something that we teach our CDREs, is how to testify in court, because you need to be able to speak confidently. You need to have really solid numbers in front of you that you can easily reference, and you need to be able to back everything up. So that's how the court will determine, but usually the parties are able to negotiate and agree on a number for a buyout. You know, as attorneys, we're used to this all the time. What we will do is, usually it starts, both parties come to the table with Zillow and Redfin in hand. Or one person has Zillow and the other person says, my best friend down the street's house sold for 630, so that's what this one's worth. So as attorneys, what we usually do is have the parties then go get appraisals or comparative market analyses. And then we will talk again, see how far apart they are. Sometimes, people will just split the baby for purposes of a buyout and come to a number in the middle. Yeah. So next question, what happens with agent commissions and escrow fees if one party buys the other out? This is a bummer because it can happen. And so from the divorce attorney perspective, I have done this for years and years, is I will send my client to a lender at the beginning to figure out whether buyout is even a possibility. That is what you need to do before you take the listing. If you really want to avoid this situation, you need to make sure that everybody has investigated the opportunity to do a buyout, and that the court order does not say anything about a first right of refusal or a first option to buy by one of the parties, because that's just going to put you in this bad situation. And in talking with Laurel, it does seem to me that it makes it so that you really don't have a viable property available for sale. If you have this other person who has the option to interfere with an offer or stop a sale, and that's one of the sellers, do you really have a property that is available for sale? So you do have an obligation to reach out to the parties and their attorneys before you take the listing to make sure that they have fully vetted this option. If this happens, so it may be that, like I was saying, those cases where you're 6 months, 8 months into it, now they've brought in a new realtor, or you're 6 months, 8 months into it, and now one of the parties is going to buy the other party out. What happens with your commissions and fees? From a divorce attorney perspective, I'm not involved in that. That's your problem. And if you have something in your contract, or you want to do something with your broker and you want to try to enforce something in your contract, then that is something, you know, that you can investigate. I'm not going to comment on that, except to say that as the divorce attorney, of course, I'm going to push hard against that, because I don't want my clients to be stuck with, you know, this commission that they're not, you know, the house hasn't been sold. So you want to make sure that you deal with all that up front, so that you don't get into a battle with the parties after the listing has expired, or at the time that somebody's trying to do a buyout. Really important, very good question, Vicente. Thank you for that. Okay, do I have any more questions? So far, no more questions. I do want to remind you guys that if you go, let me give you the link. There's a link to the top 5 mistakes that realtors make in divorce listings. So I'm going to, or actually, Sarah, are you able to post that? Hold on here. Let me see. Everyone, and there we go. All right. So I've posted it in the, oh, that doesn't help you, does it? For me to post it in the chat. Sarah's going to post it in the Facebook group. All right. I thought I was being so clever. All right. Sarah's posting that. So top 5 mistakes that realtors make. Get that, read it, and avoid those mistakes. And then, like I said, we've got a sale going on boot camp right now, and we have our CDRE program. We are enrolling now for what's this? Enrolling for the spring. And boy, do we have some awesome people who have already been accepted to the program, and we are really, really, really excited about it. So please reach out to Steve. He is our director of enrollment, and talk with him and see if this niche is for you. You know, he's going to take some time and explore what are the best programs, and is this really right for you? Are you right for alumni? And go from there. But that is not what today is about. Today is really about that realtor out there who is trying to do this. And I hope I have given you some good answers and ideas and ways to avoid pitfalls, and just really been honest with you about kind of the attorney's perspective in these cases. You can always reach out to us in the Facebook group. You can tag me and I will absolutely answer your question. I know all of us faculty are looking at the posts and will respond if you have a question that is a legal one that we can answer. And let's see, I think that's it. Sarah, is there anything else I can cover today?
We have one last question from Ms.
Yeah.
Yeah, send it in your chat.
Oh, is that in my chat? Okay, hold on, here we go. Yeah. How do you stay neutral, and what do you say standard operating procedure when they are bursting to share their story? Okay, so I'm going to answer this for you as the realtor, is how do you stay neutral? And the way you stay neutral is you don't sit down, you don't have a cup of coffee with them, you don't encourage them to give you too much more information. It's a very clinical type of an approach, and at the same time, you're building trust. It is one of those things you will learn over time as you do it. And just as a family law attorneys, I mean, if I sat and listened to my clients burst and emote for hours, they would do it, but they would also have a really high attorney fee bill, and a therapist is way cheaper. And so they are going to want to emote with you. and they're going to want to burst out and tell you things. And it's okay. I mean, if you're doing the walkthrough and, you know, one of the parties starts to cry because this has been her dream home for all of these years, and she's just is crushed that she's having to give this up, you know, you can have empathy and say, I see this is really hard for you, and I'm sorry about that. And then she's going to go on and start trying to talk about some more things. And you can say, well, your kitchen is really beautiful. Why don't you show me what you've done in there? Right? You're like trying to kind of get through the house and get through your walkthrough and kind of merge in your empathy with keeping the process moving. And one of the other things you can do is before you talk to them, let them know how much time you have. So if you're going to do a walkthrough and you say, I'm going to be there, it's only for 5 or 10 minutes. It's really, really fast. I'm just there to take photographs for myself so I can help come up with a listing price. We will have an opportunity to talk further at the listing appointment, but I'm just going to come see your house. So don't worry about anything. It's going to be real quick. Right? So you've set the stage for what's going to happen when you get there, so that as you are trying to move things along, they are already understanding that that was the intention. But then also to just have empathy. Don't ever agree with their emotion, because they are going to take that as you are agreeing with them, and now you are adverse to the other party, and that is just going to be used as a sword in the litigation. So you just have empathy. It sounds like you're upset. I can see that this is really hard for you. And then you keep moving on. I hope that was a good answer. Certainly in our CDRE program, you know, I teach a whole afternoon plus, and you know, there's hours and hours of education about how to be a neutral in a family law case, in a divorce listing. So we can certainly tackle that again next time. We can talk about that a little bit more. Maybe I can take a few things that I teach and talk with you about that. So touch back next time for Lawyers Uncensored. It was great to be with you guys today, and I wish you a great week, a great month, and we will see you next time.